Good day, everyone. I'm John, your moderator for this webinar on the behalf of the organizer company called Conference Panel. I welcome everyone for today's webinar, which is called Recording Defense Medical Examination and Psychology Evaluation and Assessment Used in a Court of Law. So now, I would like to introduce our presenter for today, Mark R. Brengelman. Mark is an experienced attorney in administrative and professional licensure law, representing a wide variety of professional clients from licensed individual healthcare practitioners to licensed healthcare facilities and many others. As a frequent participant in continuing education, Mark has been a presenter for over 30 national and state organizations and private companies as the Kentucky Bar Association, Kentucky Office of Attorney General, National Attorney General Training and Research Institute, and Federal of Associations in Regulatory Boards. So now, I would like to hand over the floor back to our speaker. Over to you, Mark.
Thank you, John, at Conference Panel, and it's great to be with everyone today. We have 60 minutes together to present this material. So this webinar is about recording defense medical examinations and psychological evaluations and assessments that are used in a court of law. Is it allowed? We will discuss some best practices and current standards. So, based upon the content of this program, we want you to be able to identify the following, and we're going to do 60 minutes of this. We want to cover an outline of plaintiff's damages necessitating expert witness testimony on mental health diagnoses. So, some disclaimers here about what this does and does not cover. Some other disclaimers is, so as an introduction, this webinar identifies and examines the changing landscape for recording these defense medical examinations. I will try to refer to them from here on out as DMEs. As a further introduction, defense attorneys and their insurance companies, assuming that insurance is involved, like in a motor vehicle accident case, are heavily invested in disproving mental injuries and will hire their own expert witness to perform a DMA. On the other hand, plaintiff's counsel will counter these efforts by demanding to record the doctor's evaluation. Here's an outline of plaintiff's damages. How are those things objectively proven? So the necessity for use of a defense medical expert, surprising things an expert witness for the defense can do in mental health in a forensic setting. What types of doctors may perform a defense medical examination? So different kinds of medical professionals, different kinds of therapists, expert witness DMEs, what about those? Who becomes an expert witness? Well, it depends on the state rule of evidence. There is a difference here when we talk about state licensure law standards. So state licensure laws include an administrative regulation in my jurisdiction in its code of conduct for psychologists. There is a rule that applies to DMEs for psychologists. A psychological evaluation of a person involved in a motor vehicle accident is a quote assessment procedure. Using copyrighted psychological tests in your DME that are specifically defined as psychological tests under state law, either by name of the copyright test or some specific description. More examples on psychologists, say, versus physicians. There is a new case from New Jersey's state appellate courts on a decision offering guidelines. When, if ever, a plaintiff with alleged cognitive limitations, psychological impairments, or language barriers can be accompanied by a third party to a defense medical exam or require that the exam be video or audio recorded in order to preserve objective evidence of what occurred during the exam. The defendant's concerns, again, this is a quote from the court system, that the presence of a third party or a recording device within the exam room might distract the plaintiff or otherwise interfere with the DME. The court went on to rule that there are some rationales at play with advances in technology, such as having a fixed camera to record the video and the audio of both the plaintiff and the examiner. The New Jersey court wrote as well that there were concerns about third parties' interference. So with regard to recent enforcement action, as evidenced by the courts in New Jersey in these three consolidated cases, what standards allow the DME in the first place at all? So A party's demand under the applicable rule in New Jersey for a medical examination can be resisted, however, if, quote, it can be shown that its probative value will be substantially outweighed by the mental and physical distress it is likely to cause, as evaluated at the trial court's discretion. There's a discretion standard built into this rule. The Attorney General of the state of New Jersey filed an amicus brief, a friend of the court, and appeared at oral argument. They represented the state licensure board, the State Board of Psychological Examiners, the BPE. The Attorney General respectfully acknowledged, according to the court opinion, that the judiciary, that's us, the court system, has the constitutional authority, 3 parts and 3 branches of state government, to specify the conditions of pretrial discovery under the applicable rule and other rules of the court. So what are the top takeaways? Best practices, tips, and techniques to prepare for tomorrow. Did we cover it all? Examples of national codes of ethics used for guidance and how codes of ethics may not apply. You never thought your money's worth today would include learning about Elvis Presley impersonators. That wraps up our content. Thank you all for attending today. Look for our past webinars on file with conference panel. Look for the upcoming one a week from today. Thank you all for attending. Stay safe out there. Goodbye now.
Thank you, Mark. Participants, thank you so much for joining today's webinar. Have a great day. Thank you.